Hey everybody, how's it going? Good to see you guys. Give me some 5x5 so I know I have comms. How you doing, S&S Contracting? All right, so I've got a busy day to the country. I just need to know that you guys can hear me before I get the show started in earnest. Hopefully I got comms. Do I have comms? Let me know if I got comms before I keep on going here. Let me just stop here for a second. Sometimes I've got to like restart, so I just want to make sure we're good to go. So I'm headed to the gym right now. S&S, hey Jody, good seeing you. Can you guys hear me? Hey Howard, can you hear me, buddy? Before I get the show started in earnest, I'm on my way to the gym. I just want to make sure you guys can hear me before I. Okay, cool. All right. So here's the deal. Here's the deal. So Alan Beck works with my firm, and we do personal injury cases together. But Alan's specialty is civil rights and Second Amendment rights in particular. And Alan is licensed in California as well as Hawaii. And he's got a case called Wolford versus Lopez, Wolford. So I want you guys to do your research and look it up if you want to join me on my show today at 12 o'clock when Alan's going to come on live and we're going to talk about it. This is one of the rare moments in history where I'm very proud of my firm and the people that have associated and been of counsel with, because we have Trump's DOJ joining Allen in an amicus brief, which is unheard of. And so I did discuss a little bit about this a while ago, but I'll go into it a little bit more in earnest on my way to the gym here. So, in essence, the Biden DOJ, as most of the Democrat administrations have done, did everything it could to basically abolish firearms rights, and they do it insidiously. But in this case, they were joining with Hawaii and other states in anything they could, including even at the Fifth Circuit, which is usually pro Second Amendment, to try and declare that firearms accessories aren't part of a gun, basically, and that they can be restricted. So triggers could be banned, iron sights could be banned, sound suppressors could be banned. Hey, Rami, good seeing you. Everything could be banned. And Alan's case is a Hawaii case. Again, it's called Wolford versus Lopez, and Alan represents the plaintiffs. And what the state of Hawaii did in opposition and against what the Bruen case stands for said, well, look, we get it. Bruen says that we have to look at the historical traditions of America and the states to determine whether or not a gun law is lawful. So what Hawaii did and the Hawaii Supreme Court did is agree that, well, okay, fine. If you can get a concealed, because you can't even get a concealed carry permit in Hawaii, guys. I mean, I think they only issued like a couple of them over the last 10 or 20 years. I mean, it was a joke. And they did everything they can to prevent law-abiding citizens from getting firearms. There was even a racist history behind it, that they felt that Samoans were more violent, so they wanted to make sure these people couldn't get their hands on concealed carry permits. There's a whole racist purpose behind it, and other reasons. We know that the left wants centralized control over every aspect of your life, and obviously if people have the ability to fight back, which is what the Second Amendment enshrines in our Constitution, that makes it more difficult. So what happened is the Hawaii Supremes and the government of Hawaii said, well, fine, we'll go ahead and issue concealed carry permits, but you can't carry your gun in concealed. By the way, this is concealed carry. You can't carry a firearm in a private business, even though they're open to the public for any other purpose, like, right? You can't carry a concealed firearm in a private business unless they have a sign outside that says firearms are allowed in this business. And of course, the historic tradition is that if a business owner or a store didn't want a firearm in their business, they had to put up a sign saying firearms prohibited, right? Like no shoes, no shirt, no service. Same concept. And they also, I believe, and Alan can correct me later, hopefully he's listening to this live, argued that in certain public parks you can't have guns, and parking lots you can't carry a concealed carry. So in essence, what Hawaii's scheme did was prohibit you from being able to have a gun for any purpose. And typically, what would have to happen is, in order for the case to go to the Supreme Court or the Ninth Circuit, there would have to be a finding by a lower court in order for the court to bring cert, like a writ of certiorari, for example. Not the lower court, but the plaintiff. But because courts typically don't like interlocutory appeals and even writs, extraordinary writs, they want a finality or a totality of the decision, the law and the facts, not just a legal issue. But the government of Hawaii said, in order to get the case before the Ninth Circuit, of course, the liberal leftist Ninth Circuit, that enough of the issues have been resolved at the lower court to where it doesn't need to stay in the lower court. It's ready to go. It's ready for the Ninth Circuit to rule on. So Allen, because the guy's a genius, he's also an inactive U.S. Marine. I think he was a sergeant. He was a tanker. You'll see a theme with me. I like to deal with Navy SEALs and Marines and stuff like that because I know, not all of them, but as a general rule, we have a different sort of code of honor. And so Allen said, well, wait a minute. Let's take this up to the Supremes, right? This case is headed to the Supreme Court since the Hawaii Supreme Court has said, or the Hawaii government has said that, well, we don't need to have any more hearings at the lower court. It doesn't need to get sent back to the lower court. This case is ready to go. And of course, the Hawaii government argued, well, wait a minute. No, we need to hear more. We need to hear more. They're doing everything they can to keep this out of going up to the Supremes. And of course, Alan's going to correct me if I'm wrong. So that's going to be at 12 o'clock today, guys. So again, I just want you to understand, I primarily focus on personal injury and catastrophic injury cases. That's my expertise. But I'm also a Second Amendment rights attorney. But Alan handles the Second Amendment rights cases. And we don't handle that many of them because it typically will cost us more to bring a case than we can recover for our client. So unless it's something of a constitutional magnitude where we believe that we can make case law and we can make America a better and safer place for citizens, for Americans who belong on our soil, then we're going to do that. And so in this particular case, the Trump DOJ, this is so shocking to me, joined Allen and said in an amicus brief, we believe that Mr. Beck is correct in the Wolford case. And we're joining him, along with a lot of other pro-American, pro-Constitution organizations. But this is noteworthy because it was the U.S. Department of Justice, Pam Bondi's Justice Department, who joined Allen. And so this is a really interesting case because the Bruen case says that the states have to go along with our original history, because the original history of the Second Amendment was that all Americans have the right to keep and bear arms, and not just for self-defense or for hunting, but also to be able to throw off an unjust government. That was the historic reason behind the Second Amendment, to be able to be a bulwark against tyranny. And of course, we know that Maoists like the Biden White House and the Biden Justice Department believe that all power flows from the barrel of a gun, right? Their allies at the Communist Chinese Party feel the same way. And so they're doing everything they could to make it more and more difficult for us to have commonly used firearms or be able to conceal carry a firearm, et cetera, et cetera. And we know that a lot of states issued these permit schemes in violation of our Constitution, that you have to have a special permit. You have to have permission to carry. And so unalienable fundamental right, which is no more or no less important than the other amendments, like the First Amendment, to be able to carry and to be able to defend ourselves and our way of life as Americans. That's what makes us different than other countries, is that we, the people, are in charge, not the state. And of course, the Europeans hate that. The King of England hates that. Uh, Most other countries hate the concept of the people not being freeborn citizens. They like the concept of them being subjects, basically serfs, subject to the whims of the state. So the state of Hawaii, just to give you, and by the way, I'm on to the gym, so I'm driving, so this is paraphrasing a lot, but the state of Hawaii argued, well, whoa, wait a minute. Hawaii has a tradition of banning firearms. And I believe when we made Hawaii a state in 1852, Hawaii adopted our way of life and our constitution. But the Hawaii Supreme Court and other courts in Hawaii argued, well, wait a minute, our history is that our wonderful, just amazing King Kamehameha, such a great guy, the guy who used European firearms to conquer all of his enemies, and subjugate his people. Such a wonderful guy. Well, he said that firearms should be banned for common citizens. And then they went into the history of how great it was to disarm the people and prevent them from being able to fight back against unjust government. And King Kamehameha, basically what he did is, I think it was his brother, he killed him, a bunch of other people, in order for him to consolidate power using European firearms. And of course, the Hawaii Supreme Court argued, this is wonderful. This is so great. Our history comports with Bruen. But what they argued is they argued King Kamehameha's edicts and laws, not the Constitution. And at the time of Hawaii adopting our Constitution, we, the people, the American people, had our own constitutional scheme and our own Bill of Rights that said, no, we the people have the right to keep and bear arms, and not just for hunting like the Democrats think or want people to believe. It was for purposes of fighting off unjust government. And of course, the left will argue, like Biden did, well, you can't fight against an F-16. There's no way you could beat us against a nuke, right? Like basically saying, well, we would use these against the American people. And of course, people like me are like, yeah, right. You just surrendered to the Taliban and left them billions of dollars worth of American equipment and arms. You surrendered to a bunch of freaking towelheads, the Taliban, a terrorist state. And we had F-16s then, we had tanks then, and obviously you surrendered to them. And then, of course, he tried to blame it on Trump, the same way that Kennedy tried to blame the Bay of Pigs on Eisenhower, right? So that doesn't work. People like me, people in my audience understand that the person in charge is the person responsible. I don't want to digress too much, but that's the argument that they make. And so the state of Hawaii argued, well, we already had our historical scheme. And so King Kamehameha, what he did is he basically conquered all of the opposition against him and then made it illegal for them to keep and possess arms, so they couldn't fight back against him. And so basically what the state of Hawaii really did is they argued in favor of what I've been arguing forever, which is that we need to have a Second Amendment because it makes the government think twice before they try to restrict us of our fundamental, unalienable other rights, like the First Amendment, the Third Amendment, the Fourth Amendment, the Fifth, the Sixth, the Seventh, the Eighth, and so on. And Pam Bondi's Justice Department went ahead and joined Alan in an amicus brief. So I'm really proud of Alan. He's really come a long way. I think he's got his black belt in Brazilian Jiu-Jitsu now. Super good guy. I consider him to be a good friend. And Alan is the man who introduced me, Alan Beck, to Dick Heller of District of Columbia versus Heller. And so Dick Heller and I become good friends, and I introduced Dick to Chili DeCastro. So that's sort of the way it all worked out. So I'm at the gym now, so I'm going to go hit the gym, but I just wanted to share with you, if you guys want to really get some education today, you guys really want to learn about our history and about America. Yeah, and I'm looking, Pro Se America says, check out Vallejo's Rob Bibanta challenging the CCW scheme. Nice. So in any event, Alan's going to be on today at 12 o'clock, and we're going to talk more about Wolford versus Lopez and how that could potentially make invalidate the requirement that you get special permission from your government to be able to keep and bear arms in the form of a concealed firearm. And so this is a really, really big deal because being able to carry a concealed firearm, it it comports more with the dangerous and unusual aspect. And dangerous and unusual under common law simply means that it's dangerous and unusual sometimes to carry openly a firearm. It might, like in a shopping mall, if I'm open carrying, that could terrify a bunch of females with their children, right? So the idea behind a concealed carry is that people don't see it, out of sight, out of mind. It's not dangerous and unusual looking. The Democrats are trying to say that dangerous and unusual has to do with the type of firearm, which is ridiculous. The English common law and American common law tradition, dangerous and unusual always meant, always, all you Harvard and Berkeley lowlifes who think you know the law, you don't. Dangerous and unusual never had anything to do with the type of firearm. It was always the time, place, and manner that you carry your firearm. And so, obviously, concealed carrying. USMC vet says I look like a cop from Law and Order. Well, I don't know. A lot of people tell me that, but I can assure you, I'm not a cop. Um, if I was a cop, I probably wouldn't be standing up in favor of the Second Amendment. But in any event, this will be really, really interesting. The show today at noon, and you can learn a little bit about the Wolford versus Lopez case and how Alan Beck, who's argued multiple cases at the Ninth Circuit, if you go to my live shows and you can see it's going to be at noon today, you'll see a picture of him up there on the artwork on the thumbnail. He's a good buddy of mine. I really care about the guy, and I want him to be successful. And again, Alan and I work on personal injury cases in the San Diego area, and he handles the big Second Amendment cases. And so this will be a really, really good show for you guys to watch. And I'm super, super happy that you guys joined me this morning. I know it wasn't a very long show. Probably right about now is when people are going to start coming into the live. But so for all of you who are just joining me, just watch this show from the beginning. It's just a teaser of what's going to come today at 12 o'clock noon Pacific time, 12 o'clock noon Pacific time, where I have my counsel, Alan Beck, who works with the Ehline law firm on personal injury claims that we do in the San Diego, Carlsbad area, and who also is one of the preeminent Second Amendment rights lawyers in the country. He's going to come on. Good seeing you, Lynn. Lynn, I'm going to go work out, so you missed most of it, but you can watch it. It's really short. I've only been live for about 18 minutes. Come back today at 12 o'clock noon Pacific. Check out the show today. I don't know if Alan's going to be joining me on his cell phone or if he's going to be joining me from his office. So I'll probably be shooting in vertical and not landscape today, just in case he shows up on his phone. But I'm really, really glad that you guys joined me today. I hope you had a really terrific and safe 4th of July and you didn't drink too much. Hopefully you didn't drink at all. And with that being said, make sure to like and subscribe. Make sure to save, because we never know when the thought police are going to